Welcome and thank you for taking an interest in our exciting mission, which we hope you'll want to be a part of. I'm Danielle, one of the founders of the Micronation of Glamorgannwg, along with Lloyd, Vanessa and Mark, who is also trustee of the Cymru Community Trust, who offer our people and micronation legal protection. We are a group of free-thinking people who class ourselves as Indigenous, and we stand under natural law, which is also known as universal law. We are currently in the process of establishing ourselves as a micronation, thereby creating our own jurisdiction outside of the UK system, and we are working towards international recognition to officially establish this status. In this video, Mark will be telling you all about trusts and the Cymru Community Trust.
Hi there, I am Mark, and as previously mentioned, I am the founding trustee of the Cymru Community Trust, which was established back in 2011. We have been helping beneficiaries, holding fortnightly meetings and signing up private trusts since we were established, and have therefore acquired a lot of experience and successes over the years. The Cymru Community Trust was initially just in Torfaen, Monmouthshire, but now it has some trusts under its protection in Devon and Swansea, as well as further afield. The Cymru Community Trust is a private trust which has people who have declared private express trusts under its protection. So it is basically a network of trusts, as shown in the diagram, with a private express trust inside the protective bubble of the larger bubble of the Cymru Community Trust. In other words, it's a two-trust system, and everyone within the private trusts are also beneficiaries of the Cymru Community Trust. Multi-layer trust systems are very protective against many unlawful wrongdoings against you, as effectively you have multiple layers of protection. This trust within a trust structure has been used by the rich and famous for centuries to protect their assets. Some examples are Tony Blair, who used a three-trust system while he was in office as Prime Minister and supposed to be working for the public. Over the 10 years he was Prime Minister, he grew his wealth by around 20 million. So no conflict of interest there then. How about the Rothschilds? They're the richest family in the world. Apparently they use a trust within a trust system which is 90 trusts deep to protect their assets. So good luck if you want to claim anything off them. So before I look at what a trust actually is, I will look at why we use the trust system. Firstly, trusts are recognised in the current UK government and the international system. In the UK, we have the Recognition of Trusts Act 1987, so all authorities and companies in the UK must recognise trusts. Trusts are also recognised internationally by the Hague Convention of July 1985 on the law applicable to trusts and their recognition. Trusts have their own court resolving trust issues. In the UK, this would be the Court of Chancery, which is part of the High Court. Private express trusts are 100% private and confidential, so you never have to show anyone your trust documents, despite what any adversaries you're up against might say. This is extremely useful in many circumstances. When expressing a trust, you can make your own law that the trustees have to follow, and that's the only law they have to follow, as long as they're not committing any crime. In other words, you can define your own rules or law that companies are obliged to comply with. For example, when arguing with a debt collector, they may quote the Consumer Credit Act 1974, which states that they only have to provide you with the statements and a copy of your original agreement when requested. But if you're under trust law, then they have to provide you with proof of actual loss and anything else you want to request before a debt is settled. And that's what they will then need to do. And this is because under UK legislation, trust law overrides statute law. And this is stated in the Supreme Courts Act 1981, Section 49, which covers the concurrent administration of law and equity, which says, subject to the provisions of this or any other act, every court exercising jurisdiction in England or Wales in civil cause or matter shall continue to administer law and equity on the basis that whenever there is a conflict or variance between the rules of equity and the rules of the common law, with reference to the same matter, the rules of equity shall prevail. In summary, trusts are powerful when used to their full potential. Even once Glamorgannwg gain recognition and their own jurisdiction, and essentially are not even part of the UK anymore. By using trusts, we can step into their jurisdiction and their system if we need to for any matter that arises. So, what is a trust? There are different types of trust, which explains the many different viewpoints and misunderstandings about trusts. UK trusts are generally lodged with a solicitor, and many often use them as a will, either by beneficiaries becoming trustees and continuing with the trusts with their own beneficiaries, so protection of the assets is maintained, or the trustees are instructed to dissolve the trust and distribute the assets to the beneficiaries as would happen with a will. The trusts we create under Cymru are not lodged with a solicitor, as this would be contrary to the natural law we stand under, but they are still recognised within the UK system. However, we recommend that you would also have a will that reflects what you have in your trust or covers different assets, so there's no conflict. In this way, the trust is active when you're alive and the will kicks in when you die. A family trust has a grantor trustee, who is the one who grants and distributes the assets, and then there is usually one or more other trustees along with beneficiaries who are named to have the benefit of the items or assets in that trust. Because a private trust is very much like a will that is active while you're alive, it could be called a living will. In your trust, you name your beneficiaries and the items that are included, just like you would with a will. What you are doing is declaring your home, car, possessions, and anything else you want to include are not just solely yours, as your beneficiaries also have a claim on them. This offers us protection, as there are multiple parties involved, so any issue with any of those items that are held in trust cannot be dealt with by a normal court. It would have to go to the Chancery Court, as I previously mentioned. This is usually too complicated and expensive for most companies to bother with. All items can stay in your name if you want them to, but changing the registration name to your trust gives greater validity to the trust and greater protection of that asset. It is often a misconception that we have to give up ownership of our possessions and put them in a trust. But as a trustee, we can still have possession and primary use of the assets held in a trust, so nothing really changes for us. By placing items into a trust, all you're doing is declaring that other people have an interest in them, and ownership of these possessions will usually only pass on to the beneficiaries upon dissolution of the trust or upon the death of the trustees when a will kicks in. So if you think of it as putting a bubble around you and your assets, one that is difficult for the system to penetrate, you are making your possessions more secure, not giving them up. I already mentioned that trusts are completely private and confidential. This has great advantage, as no one actually has to know what is in your trust, and it's up to others to prove otherwise. But it also means that you can change your trust as your circumstances and assets change too, as you remain in complete control of its content, so you are free to buy, sell, move house, change car, provided that it is reflected in your trust document. The contents of your trust can easily be changed by either drawing up a new document or adding an addendum which is signed and witnessed just like the original. You don't even have to use it, but it could be invaluable if you need to. A trust is not only for your assets, as your relationships with organisations, corporations and other legal bodies are incorporated into the trust. Therefore, if any issue arises, your trustees can intervene like it's a third party. This is especially useful as many of the companies involved in something like debt collection and authority officials use emotive techniques which are designed to frighten or threaten the individual. The beauty of being part of the Cymru Community Trust is that Cymru can intervene on your behalf, which creates an even bigger distance between them and you and protects you from the emotional stress, as we are not emotionally attached to that issue. Having a third-party representative especially one who knows the law, as reflected by the content of our letters, will often stop the adversary in their tracks. Because you retain control, you can choose to use trust law or not, depending on the situation, but it's always there as a backup. Even just knowing that there is backup can give you more confidence to deal with things and to make a stand. One example is when one of our citizens didn't complete the census when an officer visited her. She told her that she was exercising her human rights of privacy. Even though the officer threatened that she would be fined, she stood her ground as she knew the trust would be there to intervene if it came to anything. Whereas without that backup, she admitted she would have felt intimidated and scared. I'll give some more examples in a moment, but basically we can intercept cases concerning debts, all sorts of fines and penalties, discrimination, and anything that violates your rights as a human being. A trust is basically an agreement between two or more people, though it's also possible to have private express trusts under Cymru on your own, as it is stated in trust law that no trust will fail due to a lack of trustees. So here's some examples of successes I have had with Cymru when intervening on our beneficiaries' behalf over the years. We've resolved issues with banks, lenders, debt collectors, bailiffs or enforcement agents, eliminated private parking tickets. We've drafted legal letters and notices. We've drafted court forms. We've intervened with government entities such as the NHS, local authorities, housing associations, HMRC and DWP. We've also quashed COVID lockdown fines for beneficiaries. And we've intervened for beneficiaries regarding COVID vaccines, where their employers were claiming that they had to be vaccinated in order to keep their jobs. Or they faced discrimination when there was an exemption from wearing a face covering, and intervention where employers or organisations were insisting on regular COVID testing. And in every case they backed down, the majority after just one letter. I'll give a few brief examples of cases Cymru Community Trust handled. The first is a beneficiary who was a retired pensioner who was contacted by a debt collector advising he owed £66,000 for a buy-to-let property that had been repossessed over 20 years ago. The beneficiary made regular payments to them for 15 years, but stopped paying in 2010 due to reduction in his pension following the death of his wife. As he heard nothing from the bank, he thought the debt had been forgotten about or written off. After receiving the letter from the debt collector, he was in the verge of putting his mortgage-free home up for sale, when luckily the trustees heard about it. We contacted the debt collector as his authorised representative, asking him several questions regarding the debt, and several letters were exchanged between us. After around 18 months, the debt collector returned the debt to the bank who had instructed them. The same questions were then put to the bank by the trust, who after a further 6 months decided to write off the entire debt. The bank even sent the beneficiary £200 of compensation and the trustees a food hamper full of cakes to apologise for the rules they admitted they had breached. A beneficiary was given a COVID-19 PICS penalty notice for going to a beach during a COVID-19 lockdown. Again, the Cymru Community Trust intervened, and to every letter demanding payment of the fine, a response was drafted. After several letters, the matter was taken to the Magistrates' Court, and it was our beneficiary versus Regina, also known as the Queen at the time. It advised that our beneficiary had now faced an unlimited fine from the court. We replied stating our beneficiary will be appearing in the court as a man, and that he will be convening his own court of record at the same time and place as their hearing. And we asked if a woman, Elizabeth Windsor, also known as Regina, believed her beneficiary had caused her harm or loss by going to the beach. If so, she must appear, as he has the right to face his accuser, and she must press the record, which means must prove that his actions caused her harm or loss. We attended the court. Unfortunately, the Queen didn't show up. A Crown barrister and the police officer appeared, and they seemed to be the accusers. A man existing under natural law, the judge, had no jurisdiction to fine him, and therefore he had to find something wrong with the prosecution's case in order to dismiss it. And that's exactly what happened. The judge interrupted the prosecutor and stated the prosecution has not proven its case, and therefore this case is dismissed. A limited company that traded for 5 years and never sent in a single tax return or paid a penny in taxes. Over this 5-year time span, the company received 9 penalties totaling £3,700 for not submitting tax returns. Correspondence was starting to become more threatening, court and demanding payment immediately. So in response, we completed a bank giro credit slip with a promissory note for the amount that was demanded and sent that in. This was followed up by a 3-step process letter, an affidavit claiming that payment had been made in full. This process created a private record of the parties, and we had a sworn document saying that payment had been tendered. Several further pieces of correspondence followed, which claimed that they could not locate the payment, but in return, all that was stated was by us that the private record of the parties showed payment had been tendered in full. They then claimed that a further sum in late penalties was owed immediately. The same process was again followed, another 3-step process, another affidavit, which created another private record of the parties. In reply to every letter demanded, they were advised that the private record of the parties showed all payments requested had been tendered. HMRC then referred the matter to debt collectors, and over the following 14 months, 6 letters were exchanged, each time informing the debt collectors that the matter was settled. After a few months, the debt was returned to HMRC. Further correspondence from them appeared to show the first promissory note was accepted and applied against the late penalty payments. The conclusion was that after 32 letters and 3 years, a letter was received showing that all balances were zeroed. So let's now look at how Cymru Community Trust and Glamorgannwg are working together. Here on this diagram, we have the Micronation of Glamorgannwg, where national citizens are Indigenous people. That is represented by everyone in the green oval. And then there are beneficiaries of the Cymru Trust, who are families or individuals who have created a private express trust under Cymru, and they are in the red oval. Some people, and in fact most, choose to be both a beneficiary of Cymru for trust protection and a citizen of Glamorgannwg. This solidifies your claim that you stand under natural law and the biological laws, as these are part of the constitution you have aligned with. So it's very, very beneficial to have both, but not essential. These people are those in the central overlap. The Glam box is the Glamorgannwg Trust, which is where all the assets of Glamorgannwg are held for the benefit of its people. So basically you can choose. You can either be a national citizen of Glamorgannwg, a beneficiary of Cymru, or both. So let's look at the benefits you can enjoy by joining the Cymru Community Trust. You'll receive protection and support for you, your family, and your assets. You'll receive intervention and guidance regarding any issues that arise at a reduced rate. We have trustees with over a decade's experience of handling legal and debt cases. And we have an established presence with major debt collectors over the years. We are also using the latest QR technology for our trusts. Each trust is entered onto a database and given a unique QR code. When scanned, this QR code confirms immediately that your trust is active and on our database. This is very useful to back up your claim that an item is held in trust if you wish. We can issue with labels, which you may wish to stick to your items in the protection of your trust. The labels put the agent on notice so they know they are handling property that is in a trust, and therefore they can be held accountable for their actions, and they cannot claim they did not know about the trust. The QR code can also be printed on correspondence to confirm that your trust is in place. When scanned, the QR code links to a page that confirms your trust, just like this. So, another benefit we offer is the beneficiary card, which you have the option of purchasing for around £10. This also includes the QR code and is extra confirmation that a trust is in place. It also contains some very useful wording on the back, which can be given to adversaries to explain how Cymru handles your affairs, and that you're exempt from various mandates and statutes. So, what do you need to do to join the Cymru Community Trust? First, you contact me to arrange a meeting. That could be online or in person. Next is declaring your private express trust using the Notice of Trust document. We then sign an agreement to align your trust under the Cymru Community Trust. This forms a non-binding contract that can be cancelled at any time. You sign a letter of authority allowing Cymru Community Trust to intervene with companies on your behalf. This is held on file until required. We accept subscriptions of £25 a year or £2 a month, which goes towards the running of the Cymru Community Trust. And we provide all the paperwork you need. So I hope this has helped you understand trusts and what Cymru Community Trust can offer you. If you have any questions, please do get in touch.
Thank you, Mark. If you want to know more, please get in touch through our website, or come along to one of our community market and gathering days, or one of our Wednesday workshops, which will be detailed on our website and in our Telegram channel and Facebook group, the links for which are on the first page of our website. We look forward to welcoming you. Thanks for watching.